Thank you, sir. You can put your hand down. Ms. Brown Zito, with your permission, I'm going to ask some questions in this case.
Certainly, Your Honor.
All right. So back on February the 29th of 2024, I'm going to take judicial notice of my own file. That contains all the pleadings in this case, as well as the default order, as well as the citation return and the notice of hearing. All right. I'm going to say that I signed a default order in this case. It looks like on February the 29th of 2024. No, actually it was February the 27th of 2024 when it was signed. It wasn't filed for 2 days after that. All right. So in that time, Mr. Williams was defaulted. And then subsequent to that, it looks like on March the 25th of 2024, Mr. Williams filed a letter with the court. I'm reading over the letter again, please stand by. Was it an in-person docket, Ms. Brown Zito?
I'm looking.
I think it was.
That was our in-person date, was on February 23rd.
And that's when this hearing was. The order wasn't signed for a couple of days after that. And yeah, that changes things substantially. All right, Mr. Williams, on March the 25th of 2024, you filed a letter with the district clerk's office in Jefferson County. Is that correct?
Yes, sir.
And the only thing of any substance in the letter that you stated that you really have a grounds for your motion for new trial is that you said that you did not get notice of the hearing. Is that correct?
Yes, sir.
The problem is, Mr. Williams, that you did not file an answer. In the state of Texas, Mr. Williams, unless you properly respond to a lawsuit that's been served on you, you're not entitled to notice. They don't have to send you anything telling you what the court date is or where you're supposed to appear. Now, if we had done this by Zoom, then yes, I would require the state of Texas to have sent you notice.
Okay.
But this case was done right here in my courtroom in Jefferson County, Beaumont, Texas. So they weren't required to send you any notice.
So you mean to tell me if I don't have a notice, I can't go to, if I don't have a notice to go to court, that I'm supposed to know to be there?
No, what I'm telling you is when you get served with a lawsuit in the state of Texas, you need to run to the courthouse and file an answer. And that way you have all the protections of anybody that makes an appearance in the case by filing your answer. Then the state is required to send you certain notices before they go forward with their hearings. You did not file an answer in this case, and therefore you were not entitled to any of those protections.
No, the reason why I'm saying, because I never received anything in reference to it. When I did receive it, it was almost 20 days later in the mail.
So you're telling me, Mr. Williams, that you were never even served with the lawsuit that got this case started? All right.
No,
then
sir.
You have a different problem, Mr. Williams. You're going to need to hire an attorney and file what's known as a bill of review or a motion to set aside based on no service. Okay. I can't take that up because I looked at the file and the process server signed an affidavit, or a constable signed an affidavit that said they personally put those papers in your hand or attached them to your door.
No, sir. And that's what I'm stating.
Mr. Williams, it's okay. I'm not disagreeing with you. I'm telling you, I found as the judge that they had proper service on you. So in order for you to attack that original judgment, Mr. Williams, you're going to have to hire an attorney and attack that judgment a different method than what you did here.
Okay, so, but in the meanwhile, of course, with me having that issue.
Yes, sir. The order that I signed in February is the valid order in this case, and it's going to continue to roll until it's properly challenged or modified.
So then that's what I'm thinking I was supposed to be here for today, to ask the courts to actually see about that ruling, because also that ruling was not fair based upon.
I understand, Mr. Williams, but what I just told you is that I've already made my ruling, and I do not have the authority to overturn a ruling that I made 2 months ago.
Yeah, but what I'm saying is, when I received this was a month afterwards. Almost a month after, because you can look at the paperwork and the documents.
Mr. Williams, I don't mean to interrupt you, but I don't seem to think that I'm getting through to you.
No, I understand what you're saying.
I do not have the authority or the jurisdiction to grant you what you're asking for. You are going to have to file your own lawsuit, a full-blown lawsuit that tries to change or modify the order that I signed in February. I'm not going to do it today. I can't do it today. I don't have jurisdiction. I don't have a lawsuit in front of me that allows me to do that. Okay. My best advice to you, and the only advice I'm going to give you, is that you go out and seek legal counsel to see if there's something that an attorney can help you with. Otherwise, you're going to be rowing a boat up a really hard waterfall trying to get this thing moving in the direction you want it to.
So the things that were placed on that, in that court docket,
In the
the
court
things that
order,
were
not in the document,
in the court
order.
in the court order, things that were placed in the court order, they were falsified.
Well, then
The
you should
things
have,
that are
then
there.
you should have taken the steps that you needed to take, Mr. Williams, to protect yourself, to make sure that you were at that court date on that date. Okay. So, but if you didn't know about it, if you say that the service on you is not proper, then there is a method that you could take to try to attack that. But it's not with this one-page document that you filed in my court.
Well,
There's
that was the
another
purpose.
process
Yes.
you're gonna have to take to try to get that.
Yeah,
over.
and that's what I'm saying. And then it's starting off with retroactive child support at $17,000. That's not
Mr. Williams, I can't
piece of the law.
change. I can't change.
First of all,
not.
Hold on,
Mr.
stop, Ms.
Williams, you did
Whoa, whoa, whoa.
get notice. Oh, I'm sorry.
Okay, all right,
You
yeah.
did get notice.
Y'all need to stop arguing with each other. This is my courtroom, and I'm just trying to tell you what the law is. Just because you don't like it, just because you don't like the outcome, doesn't change it. Okay. I am not going to change a court order that I signed in February based on a one-page document that was signed by Mr. Williams and filed in my court. That's not how the system works. So there's a whole set of laws out there that explains to people how it is that they can go about challenging a court order. And this ain't the method. So while I do understand what Mr. Williams is trying to accomplish, he's in the wrong car to make that happen. He's going to have to get a completely different vehicle to change it. Okay. All right. That's the ruling of the court. Mr. Williams, I really do wish you the best of luck. And I am really advising you to go out and seek legal counsel if you think that the order is not correct or that you were not properly served.
Do I need an order on this, Your Honor?
No,
Okay.
it's not. It's not what it is.
All right. I just wanted to make sure if there's anything I needed to do.
It's not. It's